I'm Lisa Shepard, and I am the Executive Director of the Chief Justice's Commission on Professionalism. The mission of the CJCP is to enhance professionalism among North Carolina lawyers, judges, and law students, a mission which it has been doing since 1998. One of the ways that the CJCP does this is to sponsor this historical video series, which is a collection of video interviews of distinguished lawyers, judges, and professionals from across North Carolina. The CJCP began filming these video interviews in 2000 as a means to preserve the thoughts of these bar leaders on the legal profession and on professionalism issues. All of the videos in this series are available to you on the CJCP website and the CJCP's dedicated YouTube channel. We are so fortunate to have had many distinguished members of the North Carolina Bar over the years, and they have much accumulated wisdom to share with us. It is important to understand that the practice of law is a profession, and doing it well requires not only substantive knowledge that one gains in law school and from studying for the bar exam, but also the value of experience learned from other lawyers. I hope that this video series will give you not only a fresh insight into the person being interviewed, but also some meaningful information about how to be a better lawyer in your own practice. Enjoy, and remember, Esse quam videri. Strive to be professional in all that you do, rather than to merely seem so.
Hello, I'm Mel Wright, and welcome to the North Carolina Supreme Court courtroom. It's a distinguished and appropriate setting for us today to talk about some of North Carolina's judicial history. The period of time that we're going to be looking at today is primarily in the 1960s, when substantial changes were made to our judicial system. Today we'll be interviewing the Honorable James Dixon Phillips Jr. and Senator Lindsey C. Warren Jr. They will be interviewed by Justice Franklin E. Freeman Jr.
Thank you, Mel, and thanks to the Chief Justice's Commission on Professionalism for making this program possible. North Carolina has had 3 court reform efforts in its 400-year history. From 1670 to 1776, we operated under the King's Courts. In 1776, our General Assembly established a court system for North Carolina when we declared independence. That court system operated until 1868. After the 1868 reform, the next reforms occurred in the 1950s and 1960s, 100 years later. This third iteration of our court system and the second reform since our founding in 1776 as a state is the topic of today's discussion. We are fortunate to have with us 2 of the 3 surviving men who helped implement the General Court of Justice in North Carolina in the 1960s. These gentlemen have distinguished records of service, as Mel has already alluded to, and they are 2 of the finest North Carolinians of North Carolina's greatest generation. In the early 60s, Senator Warren, we had court reform. The first since the 1868 Constitutional Convention. Tell us how that court reform started.
Well, it started with what is commonly referred to as the Bell Committee, a committee that was established by the North Carolina Bar Association to review the court system in North Carolina, and particularly the provisions of Article 4, the judicial article of our Constitution. And it was called the Bell Committee because Spencer Bell, a Charlotte lawyer, was the chair of that committee. And the committee contained some outstanding lawyers and also some very fine lay people who served on it. And they went to work somewhere around 1955 or 6. And they made their first report to the 1957 General Assembly. And it proved to be controversial, a number of the provisions in it. And I won't go through the details of that other than to say that the 1957 General Assembly did not submit to the people the recommendations of the Bell Committee. But in '59, they were back. And this time, they changed the leadership in the House and Senate to handle the legislation. And they were successful. And there was an amendment to the judicial article. In fact, the whole thing was rewritten, but many of the provisions had been there for some time. And the changes in the Constitution required legislative implementation. And in 1963 was the first opportunity to do that. There were some who wanted to move quickly with it, but in hindsight, that would have been a mistake, in my opinion, because there was still tension between those who wanted no changes in the Constitution or didn't like all of those that the General Assembly had submitted to the people. They having been ratified in 1962. That's the 61 General Assembly, proposing a rewrite of Article 4, ratified by the people in 1962. And there was still some feeling about it. But nonetheless, there had been no background preparation for drafting legislative provisions for the implementation. So out of that came a proposal to create the North Carolina Courts Commission. And initially, the governor, and that was Governor Sanford at that time, would make the appointments of 15 persons to the commission. And the charge was to draft the necessary legislation to implement the changes in the Constitution. And that turned out to be showing a little of the heat that was still there. It was amended before it passed for 4 members of the House and 4 members of the Senate, and me, who introduced the bill, to serve as an appointing body. Well, I stepped out of the appointing thing and let the governor's office handle that. And they did. And so the commission was appointed. The Courts Commission was appointed pursuant to that legislation before the end of the '63 session. And it did not begin its work until after that session adjourned, and that was the beginning of the implementation process.
And in '62, the controversy over the amendment by that time had pretty much abated because of the lengthy discussions in the General Assembly?
Well, yes, there were still those who opposed the changes, but it carried by a rather substantial majority of the people. And as I recall, I don't believe there was much debate going on it. It passed in '62.
I think that there were, I was trying to think the other day of the leading opponents, and I couldn't even call them to mind.
There was two or three Superior Court judges
who were against,
very much opposed to it.
But I think everybody, by that point, that it addressed the general problem of the courts, the Constitution at that time, the makeup at that time, was aware that the lower courts, the local courts, were just in a mess in terms of, well, they all come into being by local legislation taken simply at the behest of the local legislators in the county or city. No attempt, as far as I recall, at coordination with the rest of the system. It's just, we need a court in Laurinburg, give us a judge, and we'll take it from there. And so I think there was a general sentiment that was so overpowering that something had to be done about that element of the court system that it was sort of a given by that point. And
another element of that was the so-called justice of the peace system, where people were appointed to serve as a justice of the peace in counties, sometimes special legislation for that county, to be appointed by the clerk or the county commissioners or some group. And there were a host of those in every county in the state. And they had minimal civil jurisdiction, but could try certain misdemeanors. And the thing about that was the worst thing about the justice of the peace system was that their compensation came from fees they assessed. But in a criminal case, they could not assess a fee unless the defendant was convicted.
A lot of convictions back then, I expect, weren't there?
A terrible thing to have, but that existed, and of course, we wanted to take care of that also.
Yes, sir. Well, in a sense, it's remarkable that even by 62, the controversy had pretty much abated because you had so many vested interests that had to be dealt with. As I've read somewhere, there were about 925 or more justices of the peace by 62.
Yeah.
And the mishmash of recorders' courts and mayor's courts with this limited but diverse jurisdictions scattered all over the state.
Different almost in every county.
Yes, sir. I know in my native Surrey County, we had one in Pilot Mountain, confined to that area, which was a town of about 2,000. One in Mount Airy, Recorder's Court in Mount Airy, and then one for the rest of the county. 3 Recorder's Courts in one county at the time of about 50,000 people. And each had their own separate forms, own separate costs of court, jurisdiction, etc.
It was a mess.
Yes, sir. And, but all of them wanted to preserve their territory in each of these counties, and I'm sure all fought and would and continued to fight up to a point, had to.
And a lot of those local judges in that time were political forces in the county or city. That's certainly the case in Scotland County. The major political force in that county in those years was the judge of the little recorder's court there. And he exercised a lot of power over an element of the population, and it was quickly turned into political force. So that was another thing that I think encouraged the general sentiment of something that's got to be done about this situation. It's just a mess.
One of the big battles over the Constitution was that there were several proposals of the Bell Committee in their legislation to really legislate, to write the law in the Constitution, certain features of it. And that was bitterly opposed by the legislators, who did not want it to be that way. they wanted the General Assembly to have the authority to make the rules and regulations concerning the court system. So that was a big fight that took place, and the legislative opponents of those changes prevailed, and therefore it had to be a body appointed by the General Assembly to propose the implementation of the changes.
Senator, what were some of the changes specifically that you recall that emerged from that commission in the first 2 years, 63, 65?
Well, the first thing, and the thing that we devoted our early attention to, was the courts below the Superior Court. The new constitutional provisions provided for a uniform court to take the place. And we had to prepare and propose the legislation to create what is now the district court system. And that process was started in 63. It was presented to the 63 General Assembly. And I think we had 30 judicial districts at that time. And we decided, instead of trying to do it all, one implementation for the whole state, that we would do it over a period of time. And so initially, beginning in 65, that's when that legislation was first passed. I think there were 5 judicial districts began the process of putting in place a uniform district court in those judicial districts. And that continued in 67, and that continued in 69 when the last districts came into place there. And the effect of the implementation of the district court was to abolish all of the courts beneath the Superior Court that existed at that time. All of the county courts, the city courts, abolished the justice of the peace system.
In phases, in those 3 phases you mentioned, in other words, as the judicial districts.
Yeah, by judicial districts, yes.
As the district court came into being in those judicial districts in 60, late 60,
65, 67,
67,
and 69.
then though all the courts in that area were abolished and put under the district court.
Only when the district court was put in place, yes. That's right. And so it was completed in 69.
And that works increasingly, surprisingly to me. I was concerned, I remember at the time, about how the phased-in development of the district court was going to work. It seemed a little odd when you first thought about it, but it was a stroke of real, I won't say genius, but smarts to realize that it would have been unwieldy and almost unmanageable to do it all in one fell swoop. And the phasing in was the real grease that made that all work, I think.
Was that a decision of the commission to phase it in?
Yes, yes, absolutely, it was. And of course, in phasing it in those districts, say the 5 districts, and I think Wake was in one of the districts that was the first to go.
Yes, sir.
And the law then provided too that the clerical work for the district courts would be handled in the clerk of Superior Court's office. One clerk's office for the 2 trial divisions. And they had been dabbling with the county courts and things of that kind, but nobody knew much about it. But the clerks of Superior Court then became state offices, not county offices, as they were under the old law.
Yes.
And they did the work for the two trial divisions.
And the same with, presumably, as I recall, with what were called solicitors until the new court system was
Yes.
phased in, and then they became known as district attorneys.
Right.
But as I recall, the 30 judicial districts were the same geographically for all purposes: Superior Court, District Court, and the prosecutorial district,
That's correct.
which was sort of the underpinning,
were.
one of the underpinnings
Yes.
of the court system, a unified, uniform court system.
Well, the district attorneys, you know, we had solicitors who were part-time prosecutors, and they were elected in the districts that they served, the judicial
Yes.
districts they served. And they practiced civil law when they weren't prosecuting. And now with the unified trial divisions, Superior Court and district courts, once that was established, there was a need to reorganize the prosecution. And we came with the legislation to establish district attorneys with such assistance as they may need, depending upon the workload in each district. And those district attorneys would prosecute all the cases, both in the district courts and the superior courts. And they're still doing that
Yes.
now. And I think that's worked pretty well.
Did away with the
Solicitor,
position and did away with the part-time nature of it,
yes.
and did
full-time
away
work.
with the recorder's court solicitors and mayor's court solicitors,
Right,
and combined all that under one elected district attorney who appointed his assistants or her assistants to prosecute in the
That's
in the lower
correct.
courts and superior courts.
and the legislature makes adjustments in the numbers of assistants periodically.
Yes.
And but that's the way it was started, and it's still in existence today.
Well, now, once you all finished your work in '63 and made your recommendations with regard to legislation, then in '65 or thereabouts, there were further changes that you all, the commission, thought needed to be made, particularly with regard to the appellate courts. Isn't that right, Judge Phillips?
That's correct. And just let me say this, and then I'm going to let the judge handle it. The Bell Commission recommended an intermediate appellate court in '69 and '59 and in '61, and the legislature said no. We had a different view of it, and we felt that we were going to need another appellate court. And so we drafted another provision to amend the Constitution to provide for an intermediate appellate court. And Judge had a major part in drafting the legislation and bringing that all together, and I'll let him talk about that.
The sentiment that drove the new appellate court through to final conclusion was based essentially upon the realization that the Supreme Court was literally unable with the new system to handle the workload that was going to be coming, and that something had to be done to relieve that burden. Well, the first thought, of course, was one that the legislature rejected out of hand and should have, which was to let the Superior Court do a final review of the district court decisions, which was impossible when you think about it.
Yes.
I don't even remember what the nature of the review was to be, whether it was reviewed de novo, which would have been a lot easier than the idea of having a Superior Court judge sitting up and ruling as an appellate judge issues of law and fact out of the new district court, which would have been an abomination strata work, and it was realized that that was not going to do, and the legislature rejected the idea out of hand, and should have. So that's when attention turned to the structure of a new appellate court in between the trial divisions and the Supreme Court. And we looked at a lot of different basic approaches to how to work the division of effort while retaining the supremacy of the Supreme Court in relation to the Court of Appeals. One thing you could have done was to divide the workload up by subject matter, amounting controversy, with the Supreme Court only handling a certain category of cases on the criminal and civil side, and the appellate court taking others by subject matter. And that was early rejected in the deliberations, and it was seen that that simply was not going to work, that the division of labors were going to have to be accomplished in some other way than by subject matter division.
Such as a criminal appellate court and a civil appellate court. That idea was rejected early on.
Yeah. The idea was that two or three things emerged in the deliberations, as I recall from those days, about the basic ideas to be incorporated in the new intermediate appellate court. One was the goal of limiting review essentially to a single appeal out of the trial divisions, though with provision for review in some instances by the Supreme Court after the Court of Appeals had already acted on it. But that was to be minimal. There was not to be just an automatic 2 reviews in every case that came up out of the trial divisions. So that was one thing that was taken as a guide for how to structure the jurisdiction of the new Court of Appeals. Another was to make provision for discretionary review by the Supreme Court in some cases of what had taken place in the Court of Appeals. You had to have some categories, and those, of course, were built into it with the constitutional decisions, rate-making decisions, capital cases, life, sentence of death.
What directed to the Supreme Court.
Directed. And there was provision made for putting the power in the Supreme Court to take cases on its own motion that were pending or had already been decided in the Court of Appeals. They had that discretion, which I think was a good idea. I'm not at all sure how frequent it was used, but that power was given to the Supreme Court to sort of nail down its supremacy in the whole process. We looked at what 2 or 3 other states in the country had, what experience they'd had in going to the intermediate appellate court in the state systems. Maryland in particular we looked at, and Michigan, both of which fairly recently had gone to it, and we profited. We had people from those courts. I think one, Charles Joyner, the judge in Maryland and Michigan, I knew it somewhere back in law school days, came down and talked to us, and very helpfully. So we profited from that experience in structuring the intermediate appellate court.
Did we look at New Jersey also as a model in addition to those two?
Yes.
Yeah.
Okay. We had 2 or 3 of our members to go to New Jersey, including David Britt, who was a very able member of the Courts Commission. And became Speaker of the House in '67, I think.
Yes, sir. It's my recollection.
And then went on from there, appointed to the Court of Appeals as one of the early appointments of Governor Moore to the Court of Appeals, and ultimately served on this court, the Supreme Court. Now deceased, but a very valuable member of our commission.
One of the best things the Court Commission did, if I may brag for the commission a little bit, was the selection of that first 6 members of that court. It was really a superb set of people, which was a real blessing to the operation of the new system. Frank Huskins, David Britt.
Yes.
Judge Morris, I believe, was
Judge Mallard.
Judge Mallard was the chief
yeah,
judge,
yeah.
wasn't the original chief?
Tabor City.
Yes, sir.
Tabor City.
And wasn't Judge Peanut Morris?
Yeah.
Yes,
As she was referred
was
to, her
from
nickname.
Wilson County.
From Wilson County, was one
Yes.
of the originals. Judge Hugh Campbell.
Hugh
Senior,
Campbell,
I
that's
believe,
Judge
who I
Campbell
yeah.
from Charlotte.
Yeah.
was one of the
Yes.
original.
The working out of the relationship between the intermediate court and the Supreme Court has been smooth from the beginning, and it's the good people on both courts.
Yes, sir.
In the formative stages of things, had a great part in making that work, and a lot of it was simply on a personal basis, friendships and collegiality between the members of the 2 courts. So it has basically worked as hoped for and as intended.
One point about the process. After we had the constitutional amendment prepared, and at the same time we prepared the implementing legislation if it should be ratified by the people, we decided that as a matter of respect we should come and talk to the members of the Supreme Court. And so
Was this about 67, 68, somewhere in that?
no, this was before the constitutional amendment was submitted to the people. And David Britt and I were named by the committee to come and talk with
You and
David.
probably Representative Britt at the time, but soon to be Speaker Britt.
Well, yes, but as a member of the commission.
Yes.
That's what we were speaking for the commission. And the arrangements were made with the Chief Justice, and we met in that conference room. And they asked a few questions. They were very polite. And we wanted to be sure that there was no opposition to what we were proposing from that body.
Yes, sir.
We felt that was essential before it was ever even submitted to the people. And we got a nod.
I recall hearing you say previously that a few days after you and Speaker Britt had come over here, that you got a call from one of the justices.
Yes.
And what was it he told you?
Well,
Or it may have been she.
no, it was one of the serving justices, and he said he just said, speaking for the court, says, so we appreciate the courtesy that you showed us by coming over, and I can tell you that the general feeling of the court is one of approval, and that helped us a lot.
Yes, sir. Eased you.
I had one other thing though. Governor Moore had on the ballot at the same time we had the Court of Appeals changes to the Constitution. He had a road referendum $300 million road bill had to be voted on by the people. I had a telephone call from the then state treasurer, the Honorable
Edwin Gill.
Edwin Gill,
From Scotland County.
Scotland County man. He was worried. He said to me, I think I'm worried about this thing. It's very important for the governor to get this road bill through and for the people to approve it. And I know how controversial the issue was in the General Assembly back in '59 and '61. And I would be concerned if we had a dispute over that could impact the road bill. Well, I said the most soothing words I could come up with and let him know that I didn't tell him that what we were proposing would not be controversial with the court. I didn't feel like I should do that. But as a matter of fact, I think David and I went over and sat down in his office with him and talked to him. So we disabused him of that mind.
I know, sitting here as we've talked, Walter Brock was also, I've been reflecting on the original six appointments. Walter Brock was also one of the original
That's
six.
right, he
And
was. He sure was.
he was another
Right.
that had that relationship that you've referred to that made the transition go smoothly between the two courts. Judge Phillips, why did you all decide, if you recall, that the Court of Appeals judges would sit in panels of 3 and not sit en banc? They, unlike some appellate, unlike the Fourth Circuit that you have sat on.
Well, I don't recall any of the details of any decision making on the size of the court sitting on particular cases. I expect that it was just sort of an automatic reflex, borrowing from the federal system, which has always been the 3-judge panel with in-bank procedures available to be petitioned for by the parties or to be taken up sua sponte by the court. Voting itself to go in bank on cases. And I'm not even at all sure the extent to which the Court of Appeals has employed the in-bank procedure.
I don't recall
They have not.
that they have at all. I think they have confined themselves to the 3-judge panels, which is, well, presumably the Supreme Court can serve as the en banc court.
Exactly. And that was the general pattern of other courts, intermediate appellate courts in other states that we looked at.
Okay.
3 judges.
Yes, sir.
And we had one little provision on cases going to the Supreme Court from the Court of Appeals. If there was a dissent by one of the 3 judges, then the losing party automatically had the right to take it to the Supreme Court.
Yes, sir. Well, I know the last group of districts came in 70. My father was one of the original district court judges in the 17th district,
right.
Surrey, Stokes, Rockingham, and Caswell.
That's when my county, Wayne County, came in at
Yes.
the same time.
And that was, my math is correct, 42 years ago, roughly, that the last group of counties and judicial districts came under the General Court of Justice.
And that's
Reflecting back on that, What do you think, each of you, and you may want a moment to reflect on this, what do you think has been the greatest accomplishment of the General Court of Justice for the state?
Well, it's hard to know. I think the unified court system is in place, and the judicial department is stronger because of that, I believe. One thing we must say is that the constitutional amendments originally adopted to Article 4, isn't it? Provided that the court system would be funded by the state out of the general fund. That made it truly a state court system. We just one little episode on that point. A very fine Superior Court judge who was interested in what the Court Commission was doing talked with me one day, and he said, "How's this new court system going to be paid for?" And I told him he was unaware of the provision in the Constitution that put the burden on the state. And he says, "Well, that's the way it ought to be. It's a separate part of the three branches of government that we have, and it ought to be paid by the taxpayers just like the legislative and executive are. But beware of one thing. Don't let the legislature load it up with fees to make up what they refuse to appropriate, thereby increasing the cost of litigation for the people of the state." He said that back there before what has now happened in this state. And I've thought of him often. He's passed away many years ago. But I think that's a principle that ought to be followed. It's up to the General Assembly to provide the funds to run the judicial system in this state out of the general fund. And don't make it difficult for people to use their courts.
There were certainly, particularly the local courts, and some of the clerk's offices, as I recall, were fee-based courts or fee-based clerk's offices.
They were.
Before court reform, a great potential for abuse, and perhaps one of the more insidious practices of the system before court reform. Judge Phillips, you?
Well, I think it's that the idea of the unified court has been realized, and the virtues of the regularity, the firm structure is such great odds with the hodgepodge that fomented the whole movement toward unification, that the thing that has made it work is the unification ideal. It is a good, solid, well-structured court system that is working as was hoped and intended. So I think it really is just a fulfillment of the gut feeling going into it, that the way to get this court system the way we want it is to make a unified system with well-structured design, trial, and appellate divisions. It just has worked.
There's one other thing that I think that the Courts Commission did that ought to be recognized. We had, at that time, a jury system for the superior courts that was full of statutory exemptions of various people, professionals, working people in certain areas. And we felt that there were so many of those that people trying cases before juries were not getting a fair cross-section of the community, and that there was no reason to have those exemptions. So we provided for to each county to have a jury commission to be appointed, one I think by a resident Superior Court judge, one by the clerk, and one by the county commissioners. And periodically they were to get the voting pool straight. And there were several options that they had on that thing. But the statute that was passed provided that serving on a jury is a public service and should be honored and looked upon in that respect, and that there are no exemptions except for people who are ill, sick, people who are too old, and several exemptions that are in there now. But they're not exemptions of persons, they're exemptions of by reason. And I think we've had everybody, a district judge in each district, if a person is unable to serve by health or some other reason, can appear before the court begins, the session begins, and offer an excuse. And you leave it to the district judge to do it. And a lot of times they excuse them or they postpone them to a more convenient date for them.
Yes.
And that's the way it works now. And I think that's been an improvement.
The controversy about the administrative office of the courts being established, was that more over who would appoint the director, or was it more over even having such an office?
Well, the Bell Committee wanted to mandate it and write into the Constitution. And I forget what that language was, but ultimately a compromise was reached, I think, in the Senate in '61 during the implementation process to insert in Article 4 the same language that's in there now, which gives the Chief Justice the authority.
The authority.
Yeah.
Well, where did the idea of an administrative office of the courts to assist the Chief Justice in overseeing the system, where did that come from?
Well, it may have come from the federal system, which operates essentially under the domain of the administrative office. A very powerful organization, and it's worked. And I'm not sure, I was thinking here as you spoke, I don't remember whether those other states that we looked at had administrative officers as a part of their realignment of the court system. Possibly they did, but I'm sure it was looking at least to the federal model. And it's so sensible that, but it would have been an impossibility with the hodgepodge of local courts. Nobody could have kept a saddle on that mess.
Yes.
Nobody would have wanted to be on the administrative office.
Yeah. Well, it's the wise thing for the business-like administration of the court system.
Well, it's also afforded the system an advocate, if you would, day to day in the legislature to advocate for the court's budget, to advocate for things that will improve the administration of justice and to defend against
Right.
items that might detract from or erode the power of the
Exactly.
General Court of Justice.
That person presents the budget for the judicial department.
Yes. Well, let's talk about the commission itself, the courts commission, the membership. How many lawyers were on it? How many lay people? Who made the appointments?
Well, the original appointments were made by 9 people. 9 people appointed 15 members. That shows you how much concern there was about.
Who do you recall? Some of the 9 that were
Yeah.
appointing authorities?
Oh, well, I can't really remember who they were, but they were prominent legislators. They all held key committees in the General Assembly, and I've forgotten who is that. The governor was the 9th one.
Yes.
There were 4 from the House and 4 from the Senate. And
then the governor appointed the 9th member.
no,
Or
he was the 9th.
He was the
member.
9th member. Okay.
He was the balance in it. And they did a remarkably good job, I think, present company excluded. I'll just name some of the people that served. I wrote that down on the note here, so most of these people are now deceased. But David Britt, Pat Taylor, Earl Vaughn from the House,
Yes.
all 3 of them became speakers. And
2 of them went on to the Court of Appeals.
3 of them were speakers during the implementation process. And that helped a little bit.
Yes.
Ruffin Bailey, a Raleigh lawyer, was a member,
And a state senator.
and a state senator. Wilbur Jolly was originally appointed. He was from Franklin County. He served for maybe 2 years and then resigned. And it may be that Ruffin took his place. Gus Zollicoffer
From Vance County.
from Vance County, who served in the House for a long time, sometimes referred to by his colleagues as Zollicoffer No. They called the roll in those days. And he was a very good member of the commission.
And he was always the last in the roll call.
Yes. And don't let me forget Jim McMillan, who became a U.S. District Court judge,
Yes.
who had served on the Bell Committee. And I think he was about the only person we had on the Courts Commission that served on the Bell Committee. But he brought a lot of valuable info. He was a trial lawyer, and he had much experience in the
By that
courts.
time, Spencer Bell was on the 4th Circuit Court
Yes,
of Appeals.
that's correct. He was on the Court of Appeals, and but he died before the implementation process was completed. Jim McMillan was a valuable member. Another one, and this was a very good appointment, I felt, Alex McMahon, a lawyer, but at that time, the advocate for the county commissioners of North Carolina. And he had been with the Institute of Government at one time. But Alex was very helpful in working out the matters that involved the county commissioners, that involved the clerk's office, all of those sort of things. And he just was a very good influence with that constituency because they trusted him and had a lot of respect for him. Judge, can you think of some others that I've forgotten here?
I think you about called the roll of the ones that stick in my mind.
Oh, I'll tell you, only one lay member of the commission.
Yeah.
The Honorable J.J. Monk Harrington,
From Bertie County.
Bertie County, longtime state senator,
Yes.
now deceased, was a good man, and he told me before his death, about 3 or 4 years ago, I went to see him and had a nice day with him. He told me of all the time that he served in the legislature, the thing that he enjoyed the most was service on the Courts Commission. And he says it was an eye-opener for him, and that he enjoyed the close relationship that we all developed with each other over a 6-year period. And he had a practicality about him that a lot of us didn't have in talking about some of the things we were doing. But he was the only lay member. Yes. The Bar Association appointed the attorney from Tarboro, Taylor, Herbert Taylor, to come and talk with us, and I said certainly we'd be glad to have him there. He would come to a lot of our meetings and sit there. And then we also had, who else would sit there? The president of the state bar came at that time. I forget his name. But they did that, and let me say here too that all of our meetings were public meetings. Anybody who wanted to come and listen to what we had to say. We had a few public hearings on various issues that were held in the legislative building, but we never closed the doors.
Thank you, Judge Phillips, Senator Warren, for sharing with us your experiences of nearly 50 years ago now as the new unified uniform court system in North Carolina at the time was evolving and developing, and thank you both for making it happen because I know in my work in the courts over the years, I have learned that North Carolina is looked upon nationwide as having one of the best court systems in the United States, and it's because of the work that the two of you and others on the Courts Commission did. Thank you both.
Thank you, sir.
Thank you.